Delaware is where the majority of U.S. corporations are incorporated. It's actually 2/3 of the S&P 500 and 85% of IPOs are Delaware registered corporations. Why? Because it's got favorable corporate law, it's got a very well-developed body of case law, so that gives lawyers comfort in giving opinions, and it's got the Delaware Chancery Court, which is where essentially you don't have to risk a jury trial for business litigation. So it's where a lot of lawyers will advise their clients to incorporate new companies. So why is Delaware interested in this? And why did Delaware pass a bill almost unanimously in both houses of the legislature on June 30th, which took effect August 1st, that enabled Delaware corporations to incorporate on a blockchain? And the answer is, if you think about what I just described for a blockchain, it enables you to share information at the same time among multiple parties. So that's going to have a big impact on how financial instruments are administered. But if they're still in paper form at their inception, then you've got a break in the digital chain. And so the aha of the Delaware Blockchain Initiative is now we can actually digitize the incorporation at the moment of inception, not just putting it on a PDF file. That's not what I'm talking about. I'm talking about creating the registration itself in digital form. It's never in paper form. And once it's on a blockchain, then all of the things that you do to administer that financial instrument can be handled through smart contracts and recorded on a blockchain. So you can now automate proxy voting. You can now automate dividend payments. You can now automate stock splits. In fact, actually, you can automate a lot of corporate governance. In the process of working with the state of Delaware, which, by the way, my company did instantiate the Delaware Blockchain Initiative. It was my CEO's idea. He pitched it to the governor of Delaware, and he got it right away. This was a big deal. This was going to enable a lot of processes in the financial services industry that are currently manual and error-prone and slow to be digitized and sped up and with a lot less errors and fraud. And one of the things we learned about in the process is the magnitude of mistakes in corporate administration is surprisingly high. More than 70% of the companies that do initial public offerings have to go through forensic audits of their capital structures because there were foot faults along the way. There were shares issued that weren't legally authorized. There were more options granted than were legally authorized in the option pool. That's very common. And believe it or not, when we went to the SEC with the head of the Division of Corporations, he actually shared that there have been some public companies where that has happened. There were more shares listed as outstanding on the 10K of an SEC filer than there were legally authorized in Delaware. And that usually comes up in proxy voting, contested proxy vote situations where someone will actually go and challenge whether the shares outstanding were actually legally authorized. It happens even in the companies that should have the best records. So in the case of Delaware, they were very interested in this because they get their franchise taxes on time if all of the shares are authorized on time. So how this will work is that a smart contract will put the rules of the corporation in the whatever is agreed in the bylaws into a smart contract. So no shares will be authorized. No shares will be issued unless there's a valid authorization that came back from the state of Delaware. Therefore, you won't have any foot faults. And for example, if a company wants a 2/3 vote on issuing new shares, the smart contract will not allow those shares to be issued until there's a 2/3 vote of the shareholders. So it enables the automation of a lot of corporate governance and, frankly, prevention of a lot of these mistakes. And that is why Delaware took the lead. Now, it turns out also, for those of you who are not in the equities side of the business, that Delaware is a really important state for the credit side of the business as well, because UCC filings are the liens that the lenders file to instantiate the lien that they have on the security interest that's pledged on a secured loan. UCC filings are all over the place. They're in securitizations, they're in leveraged loans, et cetera. And there are so many UCC filings filed every day, and it turns out that UCC filings are filed in the state of incorporation of the borrower. So therefore, since most companies are incorporated in Delaware, UCC filings are filed in Delaware. The legal community is so excited about the prospect of being able to automate UCC filings. And if you think about what that might mean, you can actually tie the UCC filing to collateral valuation systems. That's not something that can be done right now because it's totally disconnected. So we now have a digital chain to say, well, gosh, if the value of the collateral has dropped, I automatically need to call my client same day, intraday, for more collateral. And right now, you wouldn't be able to do that. And by the way, they could post that collateral to you same day automatically, or you could close out the position automatically, and all that happens same day. Right now, something like that would take a minimum a week to get done. There are also interesting things that happen in asset-backed securities transactions. For example, the UCCs typically, the offering documents give lawyers typically 36 hours to actually make the UCC filing, so the investors are technically unsecured for those 36 hours. And think about think about the tail risks that can happen if something goes wrong. Typically it doesn't early in a securities offering, but if something does go wrong and the investors are actually unsecured because the UCC filing wasn't filed properly. Also, UCC filings have to be updated. They only last 5 years. Well, you know that a lot of loans are longer than 5 years, and there was a really interesting case with an accidental release of a lien for, I think it was General Motors, that resulted in tremendous litigation, and again, mistakes in that administration actually happened. In fact, the court said that even though the lien was accidentally released, it was released, and therefore, I think JP Morgan was the lender. Guess what? Your position is now unsecured. So these kinds of things, when the ball drops like that, can be very costly. And so if we can automate some of the administration, we can reduce risk in the financial system.